Today's rescheduling announcement has triggered a 60-day federal window for state licensed medical cannabis operators. DOJ has changed the federal cannabis landscape for every state licensed medical operator in the country. If you hold a state medical marijuana license, the next 60 days matter. The Department of Justice placed state licensed medical marijuana into Schedule 3 of the Controlled Substances Act, specifically FDA approved drug products containing marijuana and marijuana that's subject to a qualifying state medical license. A separate, broader rescheduling hearing for the rest is scheduled to start June 29th. Alongside rescheduling, a DEA registration pathway was also highlighted. State licensed medical operators can now apply for federal DEA registration. In this context, your state license is conclusive evidence of a state authorization. The DEA must grant registration unless there's a specific public interest or single convention concern. And the regulation is explicit that, in general, registrations of applicants operating under well-regulated state programs will be granted. Here's the piece to understand, though. There's a 60-day window. Applications filed within 60 days of the Federal Register publication get a 6-month processing commitment and can continue operating under state license during the review. Applications filed after that window get neither of those. If you're an operator who's going to file eventually, it's a strong argument for filing within that 60-day window. One more thing, the order specifically notes that Schedule 3 registrants are no longer subject to 280 of the Internal Revenue Code. This is a tax issue, but it's probably the single biggest financial consequence of this order. So make sure you talk to your accountant or tax counsel or whatever tax professional you use. If you want to think through whether to file within the 60-day window, shoot me a DM and we can chat.